The NDIC Annual Sensitization Seminar for the Judiciary, held in collaboration with the National Judicial Institute, had a roll call of FCT and senior High Court judges who gathered at the NGI to listen and share ideas on the management and practice of financial law. With the theme, Challenges to Deposit Insurance Law and Practice in Nigeria, this two-day seminar aimed at linking the role of the judiciary, seen as last hope of the common man, with the enabling act of the NDIC as the protector of the depositor. The 2016 NDIC NGI Sensitization Seminar is the fourth in the series of such annual sessions. With the previous edition adjudged quite successful, the present session is hoped to be more fulfilling. Host of the event and administrator of the Judicial Institute, Justice Roslyn Bozimo, said that as Nigeria grapples its way through economic recession, we must all learn from the experience and forestall a reoccurrence.
As Nigeria is making resolute efforts to struggle its way out of economic recession, we must all avail ourselves of the opportunities to learn the pertinent lessons from this unpleasant experience and to forestall its reoccurrence in the future. The key, therefore, is constant enlightenment on important issues and that relate to the Nigerian banking system and our economy as a whole. This sensitization seminar is one of such avenues. We will continue to collaborate with the NDIC and other relevant stakeholders to ensure that judicial officers are properly kept abreast of the trend of development in the financial system. A judge must be properly equipped at all times with the right information in order to discharge his duties with utmost professionalism and efficiency. I concur with the late Nelson Mandela when he said, and I quote, "Education is the most powerful weapon which you can use to change the world," unquote.
This sensitization seminar, the NDIC hopes, will create an avenue to address areas of concern among the judiciary.
We always welcome the opportunity to partner with the National Judicial Institute and the judiciary to enhance and contribute significantly to the building of capacity of our judicial officers. These sensitization seminars serve as an avenue for cooperation to educate and enlighten relevant stakeholders, answer pertinent questions, and address issues of concern. The corporations consider this a very valuable contribution to the development of the Nigerian financial system, especially in times such as this, when we're collectively making efforts to bring about measures to overcome the recent economic recession and ensure that our great country is rededicated and repositioned on the path of prosperity.
In his opening address, the Chief Justice of Nigeria, Mahmoud Mohammed, GCON, advised judicial officers to kept constantly informed and stressed that these trainings have made judges better advocates of matters that bothers on deposit insurance law.
The judges need to be kept informed of current developments in the Nigerian financial system. To this end, I'm aware that the corporation has continued to make concerted efforts since 2012 to improve the awareness of all Nigerians, including your lordship, regarding the law and practice of deposit insurance in Nigeria. This laudable initiative has undoubtedly played a significant role in equipping our judges to better advocate on matters that have directly or indirectly bordered on banking in Nigeria and improving our jurisprudence on deposit insurance law.
Presenting the opening paper, Mr. A.A. Adeleke, Director, Bank Examination Department, NDIC, expatiated on the structure of the economy, the financial system, component of the Nigerian economy, the operators and players involved, as well as expectation from the judiciary. These created the platform on which other presenters delivered. Mr. Adeleke emphasized that for any economy to grow, it must have a strong financial system. He said the country's financial system can liken to the anatomy of the human body. Though made up of many organs working together, is controlled by the brain. Banks, he said, are the most important part of the financial system.
Permit me when I talk more about banks, because it's not because the other parts of the system are not important, but because of the overarching position of banks in the financial system. The banks that is corporate bank always advertise the fact that in year prior to even the amalgamation of our country, not talk of independence. So that is how way back the Nigerian banking law has evolved.
The Nigerian banking culture can boast of a rich and long evolution dating back to pre-amalgamation period. Major milestones have been achieved since then, including the Banking Ordinance of 1952, establishment of the CBN in 1959, and the NDIC in 1988. The introduction of the Structural Adjustment Program, SAP, brought about the influx of more banks. Despite all these, one recurring issue which remains the crux of the matter is what lies the fate of the depositor when the banks runs into troubled waters.
That if the bank is in trouble, the person to be protected, the person whose money is at stake, is the depositor. And it's important that our judges understand this, because NDIC that has been set up in order to protect these depositors, sometimes even our courts, in trying to find for those who say that they are owners of the bank, pronouncements are made to say attach not only the assets of the bank's institution but the assets of NDIC. It becomes a little bit curious. Who are we protecting? Whose money is at stake? So, ladies and gentlemen, that is the cause of the matter. Throughout the discussion that we had by various speakers, they will be coming back to this, the role of the NDIC and the need to protect the depositors whose money is at stake.
The financial system, Adeleke stressed further, can be broken down into money market, capital market, and development financial institutions.
Money markets only concern banks. Banks deal with money that are there not more than a year. The capital market deals with investment in shares, and those who buy shares, even though they sell their shares, they are only selling to other investors. So that money kept on being there because they are looking for profits. They are looking for the dividend that will come from their investment. Then we have the government financial institutions that are always been set by government to address certain specific gaps in the economy, bank of industry, bank of agriculture, so that they can address those issues that are particular to those sectors of the economy. Then I group the other financial institutions like insurance businesses, the Nigerian Social Insurance Trust Fund, the pension fund custodians, which are getting so much money, mobilizing so much money now that they are trying to release into the economy so that the economy can grow.
In 2009, the financial system experienced the collapse of the stock market. That led to the holistic examination of the financial subsector, birthing consolidated supervision which guides for leakages.
This consolidated supervision has helped us to be able to look at all the financial landscape holistically.
Having set the tone for the discussion, other speakers took time to elucidate on the different areas of the theme. With all sense of pride, Mr. Gabriel Christopher said the Nigerian financial system is one of the best in Africa and believes that even with the current economic recession, the nation's financial system is sure to get the economy back on track.
How quickly we are able to get out of the recession will depend on the soundness and the strength of our financial system and the integrity, moral strength, and the fidelity of the persons who are charged with driving the system.
A sound financial system should be able to facilitate management of the economy, provide non-inflationary support to the economy, achieve greater mobilization for savings, effective and efficient channeling of funds, ensure that no viable project is frustrated because of lack of fund. And also, the system must achieve or assist in achieving significant transformation of the rural sector through greater integration and linkage in agriculture, commerce, and industry.
So, a financial system that is not able to achieve this objective will not be a system that can drive our economy out of the recession. However, in Nigeria today, the tragedy is not in the lack of institutions. We have all the institutions that we require that can see us up to the roots. Unfortunately, we lack that political will to enforce extant laws and regulations, and the continuing unwarranted interference in the running of these institutions by the powers that be. Institutions are not allowed in the financial system to be run as they have been designed.
He advised that for the financial system to remain vibrant and corrupt-free, all players should play by the rules and guilty parties should be brought to book.
It is very important that whatever we do or whoever is found guilty is subjected or commits an offense is subjected to the due process of the law and is punished to the fullest extent of the law. This will serve as a deterrent measure and ensure that our financial system remains robust and has integrity.
Having understood the financial system and its working from the financial expert, it was then time to understand the role of the judiciary in the financial system. Opening this second session of the seminar was Professor Kayinsola Ajayi, SAN, who was represented by Muyiwa Balogun. Speaking on the role of the judiciary in promoting financial stability, Mr. Ajayi stated,
"Judicial officers, just like other public officers, are impressed with the constitutional duty to promote the welfare of Nigerian citizens and economic growth."
He stressed that the specialist knowledge of the NDIC and other similar agencies should be a reference when judges handle financial issues to ultimately save the country's financial system.
That the Russians have the constitutional duty to be concerned about financial system stability. So the first thing that we talk about in terms of the role of the Russians is that the Russians must first understand and accept and seeking to take decisions on the merits which are within the province of the regulators set up by statute.
Professor Ajayi stressed that judges should understand the status setting up the CBN and NDIC and endeavor to uphold them since they ultimately protect the depositor.
The Russians must recognize that these statutes that we talked about, the NDIC Act, the ANCOM Act, the CBN Act, the Bank and Other Financial Institutions Act, are embodiments of policy which the legislature has codified into law. That this is the way this sector should be run, this is the way this sector should be regulated, and these are the regulatory authorities for that particular sector. So your Russians must distill that primary objective from each of the statutes you are called upon to.
Other discussant on the topic stressed on the fact that judges must familiarize themselves with the laws of the regulatory institution.
we are urging your lordship to do is to recognize first and foremost that some of these laws have been put in place to ensure that it's not just every action that should exist or be brought before you, to the extent that if representative council representing the regulatory authorities draw attention to these specific laws that will challenge the institution of the action in the first instance, we expect your lordship to take time to look at these laws and take a position on it.
At question time, participants drew the attention of the speakers to some specifics which might put the council and judges at a crossroad when handling financial matters.
We need to expand the stakeholders and let gather on the prosecutors here present, because I find that the fight against corruption, in the fight against corruption, we begin to do things that are inimical to the protection of the depositors' rights, and we need to expand that so that the prosecutors are also being carried along about the threats to the financial system.
Your lordship is quite right. I think the NDIC is seeking taking steps to have sensitization workshops for even the solicitors and the engaged to come before the lordships, so that these matters are clearer to them and they can ask for the appropriate remedies before the lordships and better guide the lordships as to the applications of these various portfolio rights and it's being addressed. And I only urge regulators to up the repercussions in terms of training the solicitors that appear before we are on the lordship.
On my part, that I believe very sincerely that if the judiciary is being asked to play a pivotal role at ensuring financial stability in the economy, then we will require and request the organizers of this program and that our legislature will also be involved, so that there should be an inventory of areas of the law where there are deficiencies, so that there will be appropriate amendments by the relevant legislative organs.
The third session, chaired by Justice Amina Augi, looked at the role of NDIC as a depositor, insurer, and bank mediator. The paper presenter looked holistically at the NDIC as an insurer, liquidator, and risk minimizer.
The role that NDIC performs as an insurer is a role that is related to its natural mandate as a corporate deposit insurer. Everything that it does, whether it's for of banks, whether it's resolution or digital guarantee, are primary functions for NDIC. And therefore, should there be a dispute or a course of action, NDIC will be the property to account for those roles. Because its roles, these are roles that are assigned to NDIC as a corporate entity and as deposit insurer. However, when we come to the role of NDIC as a liquidator, is totally a separate function, is a separate role. In fact, that role is performed on appointment by the court. Even though, as we see, by virtue of the enforcement of the NDIC Act, whenever the license of a bank is revoked, automatically NDIC steps in as provisional liquidator, and that appointment is deemed by law that be made by the Federal High Court.
In very explicit terms, the presenter explains some challenges of the country's deposit insurer.
One of the challenges is this area of realization of assets. And so when it is going to court, I get it's very challenging because I want to acknowledge that when a bank fails, it means their affairs are not in order. And what